Welcome to the Deep Dive. Today we're getting into some pretty foundational legal stuff.
We are. We're tackling the Prescription Act 68 of 1969.
Right. The Prescription Act sounds maybe a bit dry, but it governs something really fundamental: time limits in legal disputes.
Exactly. It might sound dense, and parts of it are, but it's all about legal certainty. Our plan today is to unpack this consolidated act. It actually kicked off December 1st, 1970.
And its purpose.
Simple goal, really, to consolidate and amend the laws relating to prescription. Basically, bring all the rules about these legal time limits into one place.
Okay, and when we say prescription, we're not talking about medicine here. Let's clarify that for everyone.
Good point. No, in law, prescription is like a legal clock. It can either grant you a right over time that's acquisitive prescription.
Like gaining ownership of land.
Precisely. Or it can extinguish a right, usually a debt that's extinctive prescription. It stops old claims lingering forever.
So it's the law saying, deal with it now or lose the chance. And this act isn't static, right? It gets updated.
That's right. It's been around since 69, commenced in 70, but the version we're looking at includes amendments right up to late December 2020. It evolves.
So today, we're hitting the main parts.
Yep. The three big pillars: acquiring property, dealing with servitudes, those rights over someone else's land, and then the big one, debts, plus the essential procedural rules you need to know.
All right, let's dive in. Chapter 1, acquisition of ownership by prescription. How you can actually become the owner of something just over time.
Yeah, acquisitive prescription. Section 1 lays it out. You need to possess something openly and as if he were the owner thereof.
Openly, meaning not hidden away.
Exactly. You can't be hiding it. You have to act like it's yours for everyone to see. And the key number here, an uninterrupted period of 30 years.
30 years, wow. That's a huge chunk of time.
It is. It really underlines the stability the law wants. And importantly, this 30-year stretch doesn't have to be just you.
What do you mean?
It includes possession by your predecessors in title. So if you bought land from someone who openly possessed an extra strip next door for 20 years.
You only need to continue that open possession for another 10 years yourself to hit the 30.
You got it. That's called tacking. Makes it slightly more achievable.
Okay, practicalities. What if someone interrupts your possession? Say, the actual owner shows up after 29 years and kicks you out.
Section 2 deals with involuntary loss. If you lose possession against your will.
Does the 30-year clock reset to 0?
Not necessarily. The clock isn't interrupted if you manage to get possession back relatively quickly.
How quickly?
You've got 6 months if you use legal proceedings to regain it, or interestingly, up to 1 year if you lawfully get it back some other way.
So you need to act fast to reclaim it and keep that 30-year period running.
Diligence again. But the law also has safety valves. What if the person losing the right, the actual owner, couldn't possibly have acted to stop you?
Like they were legally unable to.
Exactly. Section 3 covers postponement. If the person prescription is running against is, say, a minor, or declared insane, or under curatorship.
Or prevented by some major external force.
Right. Superior force is the term. Maybe they were wrongly imprisoned, something like that. In those cases, the prescription clock doesn't just hit 30 years and end.
It pauses.
It's delayed. Prescription won't be completed until 3 years after that impediment, the minority, insanity, whatever, ceases to exist.
Gives them a fair chance to wake up and assert their rights once they're able to.
That's the idea. Balancing finality with fairness, especially for vulnerable people.
Now, what if you are the owner, you see someone clocking up time on your property, you want to stop it legally? What's the definite stop button?
That's judicial interruption. Section 4. Serving a legal process like a summons claiming ownership on the possessor, that officially interrupts the running of the 30 years.
But just serving the papers isn't enough, is it? You can't just file suit and walk away.
Absolutely crucial point. No, the interruption lapses. It's like it never happened if the claimant doesn't successfully prosecute that claim all the way to a final judgment.
Or if they just give up on it.
Right, or abandons the judgment. You have to see it through. Otherwise, the clock effectively kept ticking. A new prescription period might start, but only after a final judgment is actually given.
Okay, that covers ownership. Let's move to Chapter 2. Still about property, but slightly different rights servitudes.
Yeah, things like a right-of-way or the right to run pipes across a neighbor's land. Section 6 says these are acquired pretty much the same way as ownership.
So exercising the right openly.
Openly and as though he were entitled to do so. Again, for that uninterrupted 30-year period. Same clock, different right being acquired.
And the opposite must also be true. you can lose these rights through disuse.
That's Section 7 extinction. If you have a servitude like that right of way, but you just don't use it for an uninterrupted 30 years,
Oof.
it's extinguished.
Use it or lose it, quite literally.
Pretty much. Although there's a slight twist for negative servitudes.
Negative ones, like a restriction.
Exactly. Where the servitude restricts the owner of the other property from doing something, maybe building higher than a certain level.
How does prescription work there? You can't really use a restriction actively.
Right. So the law says a negative servitude is deemed to be exercised as long as nothing has actually been done that impairs it. Its existence is maintained by the other party not violating the restriction.
Interesting. So as long as they don't build too high for 30 years, the restriction remains solid.
Essentially, yes. One important carve-out in this chapter, though, Section 9.
What does that say?
It makes it clear this whole chapter doesn't apply to public servitudes.
So you can't gain or lose rights over, say, a public road through this 30-year rule.
Correct. Public rights are protected differently. This act focuses on private disputes.
Okay, let's pivot to Chapter 3. This is probably the part that affects most people day to day. Prescription of debts. Extinctive prescription.
Absolutely. This is where the act really bites in everyday life. Section 10 is blunt. A debt is extinguished by prescription after the relevant period lapses. Gone. Legally unenforceable.
But there's that odd quirk, isn't there, if you pay a debt after it's prescribed?
Yes. This catches people out. Even though the legal enforceability is gone, if you choose to pay that prescribed debt, the law sees it as a valid payment. You can't claim it back saying, oh, wait, that was prescribed.
So the moral obligation, or maybe just the act of payment itself, overrides the prescription.
In effect, yes, the debt technically still existed. You just couldn't be sued for it anymore.
Now, the tricky part, the time periods. Section 11 lists quite a few different ones. How do we keep these straight?
Let's break it down. Think tiers. Top tier, the longest period, 30 years. This is for really significant long-term debts.
Like what?
Mortgage bonds, judgment debts where a court has already ordered payment, debts for taxes, and debts owed to the state for things like mining royalties.
All right.
Real heavyweight stuff.
Okay, 30 years for the big ones. What's next?
Then we drop down to 15 years. This is specifically for debts owed to the state from loans or advances they made, or from selling or leasing land. State loans, basically.
Got it. 15 for state loans. Then.
A 6-year period. This covers more formal commercial paper. Think bills of exchange, promissory notes, other negotiable instruments. Also, debts arising from notarial contracts, contracts executed before a notary public.
So, more business-focused, formal debts.
Generally, yes. And then the most common one.
The catch-all.
Exactly. 3 years. Section 11D says, unless another act specifies otherwise, this applies to any other debt.
So, your regular store account, credit card debt, contract for services like a phone plan.
Most likely, yes. That 3-year clock is the one most people will encounter for everyday debts.
Crucial question then.
Yeah.
When does that clock, whether it's 3, 6, 15, or 30 years, actually start ticking?
That's Section 12, and it's often where legal arguments happen. The basic rule sounds simple. Prescription starts to run as soon as the debt is due.
Due. But when is a debt actually due? Is it the invoice date or payment date?
It generally means when the creditor has the legal right to demand payment immediately, but there are big exceptions.
Okay, what are they?
First, if the debtor actively and willfully prevents the creditor from finding out the debt exists, the clock only starts when the creditor does become aware. You can't hide a debt to run out the clock.
Makes sense. What's the other main exception?
This one's key, especially for, say, complex claims or personal injury. A debt isn't considered due until the creditor knows 2 things: the identity of a debtor and the facts from which the debt arises.
So if you don't know who owes you money, or you don't know the key facts why they owe you, the clock hasn't started yet.
Correct. But there's a very important caveat.
There's always a catch.
The law adds a reasonable care test. You are deemed to have that knowledge if you could have acquired it by exercising reasonable care.
So you can't just stick your head in the sand and claim ignorance forever if the information was reasonably available.
Exactly. You have a duty to be reasonably diligent in finding out who owes you and why.
Now, Section 12 has had some really significant updates recently, particularly around horrific crimes like sexual offenses and trafficking. Section 12.4, right?
Yes, this is incredibly important. It reflects a societal shift. Prescription will not run the clock is completely stopped if the creditor can't institute proceedings because of mental or intellectual disability, disorder, or incapacity.
That's linked to those specific offenses.
Critically, yes. Or any other factor the court thinks is relevant related to those offenses. It acknowledges the profound impact of such trauma can itself be an impediment to seeking justice, stopping the clock entirely in those circumstances.
That's a powerful protection. Okay, let's round off Chapter 3. How can the running clock for debts be paused or reset? Delay and interruption again.
Similar concepts as with property, yes. Section 13 covers delay or suspension, as it's sometimes called, if the creditor is a minor, mentally incapacitated under curatorship, or if the debt is tied up in arbitration or part of a deceased estate.
The clock pauses.
Effectively, yes. The prescription period won't be completed until 1 year after that impediment ceases. Gives a 1-year grace period to act.
And interruption. How do you fully reset the clock on a debt?
2 main ways under Section 14 and 15. First, by the debtor acknowledging the debt. This can be an express or tacit acknowledgment of liability.
Tacit, meaning implied.
Yeah.
Like making a small payment.
Precisely. Making even a partial payment or sending an email saying, sorry, I'll pay soon, is usually enough to count as tacit acknowledgement. That restarts the entire prescription period, 3 years, 6 years, whatever it was, from scratch.
Wow, okay, so one small payment can reset years of the clock.
It can. The other way is judicial interruption, Section 15. Serving process claiming payment.
And like before, you have to follow through with the court case.
Absolutely. Same rule applies. If you serve the summons but don't prosecute the claim successfully to final judgment, the interruption lapses. It's as if you never served it.
Diligence, diligence, diligence seems to be the theme. Okay, let's wrap up with Chapter 4. General provisions, the kind of rules of the game for the whole act. Section 17 seems vital here.
It's probably the single most important practical point for anyone involved in a legal case about prescription.
Which is?
The court will not take notice of prescription on its own, ex officio, as lawyers say.
Meaning the judge won't just say, hey, wait a minute, this debt looks like it's prescribed.
Never. The party who wants to rely on prescription as a defense must specifically raise it in their court documents, their pleadings.
So if you're being sued for a 10-year-old credit card debt, and you forget to plead prescription,
you might lose, even if the debt was clearly prescribed years ago. The court can allow you to raise it later, but you absolutely have to raise it yourself. It's a shield you have to actively pick up.
That's a critical procedural point. What else in the general rules?
Important to note, Section 19, the act binds the state. So generally, government departments are subject to these same time limits if they owe money or are owed money, unless another law says otherwise.
Fair enough. Any major exclusions?
2 main ones. Section 20 says the Act doesn't apply where specific traditional laws referred to historically in the Act, using outdated terminology like Bantu law, govern a right or obligation.
Okay. Respects specific legal systems.
And Section 18 clarifies that this Act doesn't override any other existing laws that might already prohibit acquiring certain types of land by prescription. It fits within the broader legal landscape.
So looking back, this Act really structures how we deal with the passage of time and law. It pushes for action, for finality.
It does. From that 30-year rule for property and servitudes forcing open and continuous use, down to the variable clocks for debts 3, 6, 15, 30 years, it demands people act on their rights.
While also building in those important protections for when people genuinely can't act, minority, incapacity, and now, crucially, the impact of severe trauma like sexual offenses.
It's a constant balancing act. Legal certainty versus individual justice, requiring diligence, but recognizing real-world impediments.
Which leaves us with a thought for you, our listeners. We've seen the law explicitly carve out exceptions for things like mental incapacity or trauma related to specific crimes, deeming them valid reasons to stop the prescription clock. It makes you wonder.
What else could or perhaps should the law recognize as a fundamental impediment? Think about systemic issues, maybe extreme power imbalances, or perhaps complex types of fraud that take years to uncover.
Where does the balance lie between needing disputes to end and ensuring truly fundamental justice isn't timed out by the clock? Something to ponder.
Definitely. Thanks for joining us on this deep dive into the Prescription Act. Hopefully it gives you a clearer picture of how time itself shapes our legal rights and obligations.
Absolutely. Take a moment to think about those timelines. 3 years, 6 years, 30 years, they might be more relevant than you think.